My everything is you, Lord. Yeah. Oh, 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 oh. Everybody say, ah. Say, oh, oh. Say, how can I express
my gratitude
for all the many things?
all the many things you've done for me?
Words are not enough.
Words are not
Yeah.
enough to say thank you.
Say, Lord, you are my everything.
You're
Mama,
my
tell me,
everything.
how can I express my
How
gratitude
can I express my gratitude
for all the many things?
all the many things you've
Father,
done
you
for
done
me?
for me, yeah.
Words are not enough to say thank you.
Say, Lord, you are,
Lord,
you
you're
are.
my
Say,
everything.
I call you Zion.
You're my provider.
I call you Nisi. You are my battle. I call you Rapha.
A lovely good afternoon to you, everyone who is tuned in to BWTV. We are live on BWTV, live on BWF Solicitors, Facebook, YouTube, and all the social media platforms. And the program is The Community and the Law. My name is Ureku Frimpon. What is yours is ours. What is mine is mine. When we are no more, we'll have to sit down and look deep into the water and share things fairly, equally, even to my advantage. We're talking about the things that happen after divorce and how settlements are made. We have a case scenario, very popular case, that has brought us to think about the situation. Financial settlement and divorce problems and how to overcome it. We're looking at the UK perspective and the Ghana perspective as well. It's all on the community and the law next.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Are you ready for the ultimate property and lifestyle experience? Get ready for the Ghana Property and Lifestyle Expo 2023, coming to 2 exciting locations. Join us in London on the 11th and 12th of November, where leading reputable real estate developers will be waiting to meet you face to face. Be inspired by industry experts as they provide thought-provoking panel discussions and live Q&A sessions. And finally, mark your calendars for the 16th and 17th of December when the expo lands in Accra, Ghana. Experience the vibrant lifestyle and rich culture of Ghana while exploring investment opportunities in the thriving real estate market. Our expo will also feature exhibitors ranging from banking and legal services to estate and property management. Get all the support and information you need under one roof. So whether you're looking to invest, visit or simply explore the world of real estate, the Ghana Property and Lifestyle Expo 2023 is the place to be. Don't miss out on this incredible opportunity. Book your tickets now via Eventbrite for the Ghana Property and Lifestyle Expo 2023. Dream it, live it. You don't want to miss out.
Welcome back, and thank you for sticking around. It's another wonderful Saturday. And if you get to know, it's the very first Saturday of the month of November 2023. We're moving, soldiering on for God, country, and our survival as well. What is yours is ours. What is mine is mine. Financial settlement after a divorce situation. It's not a very comfortable topic to really discuss, because when people go into marriage relationships, the expectation that it will last for better or worse until death do us part. We say all those things and we commit to one another. But, well, it does happen that things and situations go bad. And when they go pear-shaped, what happens? People come in with the expectation that I'm going to help my partner develop and we live together with our family and the rest of it. Some come in with a lot of property, some come in empty-handed sometimes. But when it is over, what do we normally say? There's a situation on hand, very, very interesting and popular case that has brought us to think about this. The marriage is annulled, and the judge has given a verdict. One partner wanted a lot of properties, both in the UK and in Ghana, but the judge said you could have X, Y, Z instead of A, B, C, D, E, F. We'll be looking at that. What is the difference between annulling a marriage relationship and divorce? What happens in those two situations? We'll be looking at that. And we so fortunate to have the main man himself from BWF Solicitors with us, Mr. Bernard Owusu, the senior partner of BWF Solicitors, the man who's had over 30 years of practice behind him, very experienced and leading a very reputable law firm. BWF Solicitors are proud benefactors when it comes to the legal educational programs we put on TV live here on BW TV. So before I go into getting you bits and pieces that I asked you to follow up on, let me say good afternoon to my senior partner, Bernard Owusu. Well, senior partner I say, because sometimes you call me lawyer, eh? So I'll go over to Uncle Bernard. Good afternoon.
Good afternoon, Kweku.
It's a bit of a dull Saturday, but it's okay. We have traveled 10 months into the year and we started the 11th month. How are you doing, sir?
I'm doing absolutely fine. I was just having a chat with one of our compatriots who is relocated to the US. And you know, the US Christmas feel is totally different. Their emphasis, it's on, their typical American celebration. They don't really put a lot of emphasis on Christmas. And she was telling me how quickly the year has traveled, and just realized that we are in November. The year has gone very quick, but we are grateful for life. We are grateful for energy and joy, happiness. What I always say is that when you've not been ill before, you don't see the importance of health. Health is one of the most essential things that God has given us.
That's right.
And for me, when I wake up and I'm well and my family is well, my loved ones are well, I have my joy. That is what I hope for.
Yeah, I think you have a bit more joy this afternoon because there are a lot of people who have tuned in and are waiting for the opportunity to share in your knowledge, experience, and of course, update us on stuff that are coming. So just hold on a brief moment. We'll be taking our nuggets very soon. But in the meantime, I want to announce that we are hiring. I'm talking about BWF Solicitors is looking for a legal assistant. The role of the legal assistant is to provide enhanced support to the lawyers, including conducting legal research, drafting and reviewing documents, communicating with clients, preparing attendance, client advice letters, client care letters, witness statements, organizing and maintaining files. Now, if you see yourself as being able to play this role, we are looking for a person who has a qualification from a recognized university, where you should have a good grasp of the English language. You should have had a minimum of 2 years experience in a law firm or within a similar environment. This will be an added advantage to yourself. And you have to be IT literate and proficient in all Microsoft operating systems and software. You will be giving a very competitive salary. So if you find yourself as the person I have described, please quickly send an email to jkwewudade at bwfsolicitors.com. And you can also visit our website, www.bwfsolicitors.com, or call our Accra office number 00233508 215013, 00233504 So, yes, if you are the person I've described and you would love to work with BWF Solicitors, this is a bright opportunity. Take hold of it and come join the family. Now, I mentioned that we've traveled 10 months into the year: January, February, March, April, May, June, July, August, September, and October. Every month, BWF Solicitors Management looks into the activities and the services of each of the workers in the establishment, and one is voted the employer or employee, of the month. And for October, our own Sandra Fraser, the front office manager, is the employee of the month of October 2023. Hooray! Now, if you follow us and you've been very particular, you realize that anytime we live on any of our programs, whether on Thursday morning, Friday morning, or on the community on the law program on a Saturday afternoon, Sandra is one that provides a lot of information for us to follow, and she's been doing that so conscientiously and consistently, so very well. And Sandra, no doubt you do very well, and we congratulate you for being the employee of the month 2023. And 2023 has been very good to you, because we celebrated your birthday, we have attended your wedding, and now we're celebrating you as employee of the month. I salute you, and on behalf of everybody, I want to say congratulations. Keep the good work going. Your smile is so infectious, and everybody is happy about what you do. Well done. Thank you very much. Well, let's look at recruitment, and this is what I mentioned earlier in the week, or even on the program last week, that if you want us to send you this directly to your phone, just send me a WhatsApp message on our number 07950422780, and just say, please add me, please add me. And I've got a lot that I've added, and this has gone to you earlier in the week. The nugget: BWF Solicitors sends us things we can enhance our knowledge with and put in our repertoire. So when we're looking at any legal situation, we know that we have cases and legal brains behind it. Reasonable adjustment in recruitment is what we are looking at this week. Employers are required to make reasonable adjustments for job applicants and employees with a qualifying disability when a provision, criterion, or practice places them at a substantial disadvantage relative to a person without a disability. Employers are not required to make reasonable adjustments unless they know or should reasonably know that the employee is disabled and will be placed at a substantial disadvantage due to their disability. This is from a case, ACOM Limited versus Malone 2023 case, so to speak. It's based on the Equality Act of 2010. Now, I probably dare to try to explain, but once I have the legal brain, why would I do that? So let me go over to Uncle Ben and ask: reasonable adjustment in recruitment, when do we do it? How do we do it? And why do we have to do that?
Well, Kwaku, so as you know, the Employment Rights Act and the Equality Act lay foundation for people who may have certain disabilities or may fall ill during their employment with a particular company. And therefore, the law requires that in the process of recruitment, retention, um, the employer must make what we call reasonable adjustments, or PCP, using the necessary information that they've garnered from interviewing the employee through their medical records, or maybe conducting their own return to work processes and procedures to determine whether the employee is capable of undertaking or discharging their duties and responsibilities. So it's a very important aspect of our law, because it protects potential employees, and those people with disability.
Well, and can somebody who has a disability, having gone through the interview process and made that known to the potential employer, can the person refuse the employment when he or she comes into employment and realizes that the reasonable adjustment have not been put in place? Can I say that, well, you didn't, so I'm declining there?
Yes, so under the Equality Act, there are some characteristics that if an individual has, and is potential discrimination in the form that they haven't been provided with what we call reasonable adjustment in assessing applications to make applications for employment, or whilst working if they are injured or are unable to discharge their duties on a certain scale, then the employer will have a duty to do what we call an assessment, usually medical assessment. Some might be psychological, depending whether it's a physical or mental health issues. It includes things like making your access to employment application or form filling online and making it available to people who are both blind and have difficulties with accessing the internet. It may also be that people who work for you will have certain issues with the discharge of their duties. It's a very comprehensive law, and over the years, case law has built it. The latest one that we have was in relation to somebody making an application, and questions were to the effect that they were not directly asked, and when he responded, he also expected them to know. He was asked to make an application in a certain way,
Right.
and he couldn't make the application in a certain way, so he made it his way. The
Right.
application was to have been made online. He made it by email. And of course, he wasn't successful. He took on the potential employer, and it was held that yes, the employer obviously has breached the Equality Act. But above all, if the person is already working for you, then this need for reasonable adjustment is equally important, if not more important. So it's UK is one of the countries where employee rights are respected across board. You will know that before Margaret Thatcher came, there were issues with employee rights. It was diluted somehow, but when Labour came, if you look at the Equality Act of 2010, they changed it back and gave employees a bit more rights. So it's just basically to ensure that everybody has a fair chance at the same position.
You'd realize that making reasonable adjustment is quite expensive. You may have to change accessibility. You may have to change equipment that people work with and all that. Is there a situation where the Department of Works and Pension probably could support an organization, a small and a medium-sized organization, to make those reasonable adjustments so they don't fall foul of the law?
Yes, so the first thing to do is to do an assessment. It's very easy if the person is working for you, because then you may do what we call return to work assessment. And as part of that, you have access to their medical records, or you have your own doctor who will do the assessment they would then do a recommendation exactly as to what needs to be done. And this would be in relation to, work that involves maybe lifting or standing or sitting for long hours. What the law says is that the size of the business is relevant to what adjustments can be made.
Okay.
So if you take a business with about 10 employees and you've got one person working in the office, 9 of them are working on the factory floor, and this person is not able to work in the factory floor, asking the business to do a reasonable adjustment for that particular staff may involve capital outlay. Clearly, they will be short of staff on the shop floor, but are they equipped to deal with the office staff? They may not be. Government support when it comes to business, especially in relation to reasonable adjustment, it's not forthcoming. So they don't have particular port for businesses to say, come for this money. But there's always retraining. So if you look at the job center, for example, they always have facilities and access to help people, to retrain people for them to take on different roles in their employment or to apply to other businesses. So the size of the business counts, but the government's role is basically limited to legislation and enforcement of legislation.
Yeah. So what we're looking at, ladies and gentlemen, is an organization employing people, and you need to take into consideration the ability to do the work, whether they are limited in ability one way or the other. And it says that employers are required to make reasonable adjustments for job applicants and employees with a qualifying disability when a provision, criterion, or practice places them at a substantial disadvantage relative to a person without a disability. And the law says that employers are not required to make reasonable adjustments unless they know or should reasonably know that the employee is disabled and will be placed at a substantial disadvantage due to their disability. And Anchorman has really clarified that there may be support coming from the Department of Works and Pension, but it's not been forthcoming. There's not a big pot sitting anywhere. So, well, whatever it is, you have to look into it, take due cognizance of that, and if there's any adjustment that has to be made, you have to make that because it is required by law. We're going to into our main discussion, and you realize I've been looking at my phone, several text messages are coming through, and I know so many people are so very interested in this one. What is yours is ours. But somebody has just said to me, what is yours, take it away. What is mine, I'll take it away. Well, that could be fair, but there may be situations where it might not be the same. Settlement, financial settlements after divorce, and the problems that come with it. We're going to look at what the problems are, how to overcome that, and we'll put the UK and Ghana into perspective. But before then, I want to say thank you to BWF Solicitors, our trusted partners when it comes to the law. They are on the 4th floor of the House, 214-218 Tottenham High, 76 North London, N15 4NP. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them, book an appointment, sit down with them, present your case to them. They will give you their professional advice and opinion, and of course, take up your cases for you, whether it is nationality, whether it is family matters, employment, wills and probate. I've been hammering on that, and I want you to take particular note of that. Call them on 0208 493 7340 or 077 127 61884, 077 127 61884. BWF Solicitors, they have the ear, the time, the patience, and they speak your language. Whatever language you want to speak to them. They will arrange everything for you. Either do a face-to-face appointments, or they do a virtual either on phone or via video, and your case will be picked up and handled very professionally. BWF Solicitors are trusted partners. Then I'm reminding you, next week Saturday and the following day Sunday, that is the 11th and the 12th of November 2023, we are representing the Ghana Property and Expo, Ghana Property and Lifestyle Expo at the Oh, sorry, the name is gone. It's a hotel like Battersea, just opposite
Pestana.
Pestana Hotel. Thank you very much. Pestana Hotel, just opposite the Battersea Park, and we're going to have various property developers and people in the industry come to let us know how to invest in properties here in UK and back in Ghana and outside of the UK. Lawyer Ben Owusu will be giving the legal perspective of the whole situation, telling you what to do, what to avoid, and how to handle all those matters. So we're inviting you to join us at the Property Expo, Pestana Hotel, Battersea, opposite the Battersea Park, next week, Saturday and Sunday. We'll take these messages, and when we come back, the question is what is yours mine, or what is mine is yours, or what is mine, and what is yours is yours. Which one would you go for, and how do you tackle that? We'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate, or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Ready for the ultimate property and lifestyle experience? Get ready for the Ghana Property and Lifestyle Expo 2023, coming to 2 exciting locations. Join us in London on the 11th and 12th of November, where leading reputable real estate developers will be waiting to meet you face to face. Be inspired by industry experts as they provide thought-provoking panel discussions and live Q&A sessions. And finally, mark your calendars for the 16th and 17th of December when the Expo lands in Accra, Ghana. Experience the vibrant lifestyle and rich culture of Ghana while exploring investment opportunities in the thriving real estate market. Our expo will also feature exhibitors ranging from banking and legal services to estate and property management. Get all the support and information you need under one roof. So whether you're looking to invest, visit or simply explore the world of real estate, the Ghana Property and Lifestyle Expo 2023 is the place to be. Don't miss out on this incredible opportunity. Book your tickets now via Eventbrite for the Ghana Property and Lifestyle Expo 2023. Dream it, live it. You don't want to miss out.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Well, thank you very much for sticking and staying. We're live on BW TV, live on BWF Solicitors Facebook, YouTube, and all the social media platforms. This afternoon, we're looking at a very interesting discussion. And it's a question I'm asking: what is yours is mine, what is mine is mine. We're talking about a relationship, a marriage relationship that's gone bad and has had to be dissolved. Divorce, when it comes with all the challenges and problems, and there are particularly financial considerations with that. And I have picked that one up, and I'm asking our senior partner, Uncle Ben, to help us unpick that and understand that. In my readings, I came across two things: annulment of marriage and the dissolution of a marriage. So I was asking myself, what's the difference? Maybe I need to unpick that before we get into that discussion. Uncle Ben, is there a difference between annulling a marriage, sorry, and divorcing or dissolving the marriage altogether?
Yes, there's a huge difference. First of all, can I say good evening to our listeners and our viewers all over the country, even in Africa, Ghana, Accra, Nigeria, certain parts of Nigeria also joins us on this program. Thank you very much for always joining us. I think we appreciate your patronage. The law in relation to marriages and void and voidable marriages are different. So we have a valid marriage, we have a voidable marriage, and then we have a void marriage. If I take a marriage which is valid, then it means that all the ingredients in there are present. So if you take Ghana, we have two main types of marriage: the traditional marriage, and then the registry or CAP 127 marriage. And if you take England, we only have one marriage. So that's a marriage at a registry or church between a man and a woman. There's only one marriage in England between a man and a woman. The other ones are not called marriages. They're called civil partnership. So we're talking about marriage here. So if the marriage is valid, then there's nothing wrong with the marriage.
Okay.
So if the parties are falling out and they want to go separate ways, then what they have to do is to have it dissolved. And that's why you have dissolution of marriage.
Okay.
You may have potentially a man and a woman who are married, but for several reasons, the marriage is voidable. When we say it's voidable, it means it's not valid, but it can go on. And a typical voidable marriage is non-consummation of the marriage. So when we say non-consummation, it means they haven't made love or they haven't had sex. And that means that it's either unable, incapable, or refusal. Either way, it's grounds for the nullification of the marriage.
Okay.
So it's voidable, it's not void. And then we say void from beginning or ab initio. Lawyers like big words. So when we say something is void, it means that it has no validity.
Okay.
But they've gone to registry, they've gone to sign, they've gone before a pastor or a church, sat down, exchanged vows. So the law does not say, well, because your marriage is void, because you were either married or certain part of what we needed wasn't there. Or we've now found out that indeed it's between a man and a man.
Yeah.
Because these days with a sex change and all those things can happen. and therefore it's a void marriage. If it's void, it still have to go through the processes um, um, through the court system to have it nullified, and the court will declare or nullify the marriage, that the marriage has been declared null and void from the word go.
Good. Okay.
They all come under the Matrimonial Causes Act, either 1971 for Ghana or 1973 for UK. And when you look at the Ghanaian Matrimonial Causes Act, there is a section for nullification, and it talks about void and voidable marriages. Samoa Jan's case, I think we all know, it's a big story because it's a former Black Star and a Premiership football player. And last week, the High Court made a pronouncement and nullified the marriage because the woman was already married to a man in America. As to why she didn't tell him, I don't know. But these are some of the problems that you have if you don't play your cards very well. You may have this hanging around your neck. In that case, it's not a voidable marriage, it's a void marriage because she was already married to someone. You can't have two marriages for one person. Customary marriage, yes, you can have multiple wives, not multiple husbands, multiple wives. But under the civil processes, which we call the Matrimonial Causes Act, in England is the Marriage Act, you can only marry one at a time. And so that's the difference.
Okay.
So nullity is a court process or a judicial process or an official process to declare an otherwise invalid marriage as it is. Invalid.
Invalid. Okay.
And divorce is to formally dissolve a valid marriage. And therefore, in both instances, both parties are free to go their way.
I know in previous discussions you talked about the uh, the, the bit that ends it altogether, and the bit that you may have to wait for certain times for the finality to come into fruition. When we say somebody is divorced, then a would have gone through the process and the final certificate has been issued. Would we be right in thinking in that way?
Yes. So until you get your final certificate, your marriage is not dissolved. Because I've seen marriages before where they have gone through the initial process of dissolution and they have obtained a decree. Somebody would say NISI, I call it NASA. And then they've gone back and say, you know what, Judge, I think we were just being stupid, pedantic. We've now come back. Even it's burning better than before. And now we want to stop the process. So you put in an application, a general application on a family law form, 406, possibly pay £230. The judge will then cancel the whole process. But in Ghana, you get one certificate. So once it goes through, the judge is satisfied, he will nullify. He will give you a certificate of dissolution. And that means that the marriage is dissolved. And if you want to marry again, you have to go back to the registry to have the marriage done properly again.
Okay. Well, these are procedural matters, but let's look at the realities, if we are allowed to use that expression. People come into marriage with expectations. I am going to marry Kwesi Menu because I can see myself and him living together happily ever after. We raise our family. We get properties done together. We financially we are sound. We're thinking of going on our retirement together and enjoying ourselves and the rest of it. But it turns sour at a point. Kwesi didn't come into the marriage with anything. Ajua came in with something. Then the better part is somebody says, no, the things that you have are mine because we're married and we swore and vowed to each other and the rest of it. Why do we always have situations like that? What creates the problem? Is it envy? Is it one feeling that it's not being treated fairly, or what? What does the law look at?
Well, I think marriage is a partnership. And when you sign and say your vows, it's a commitment to each other. And in that commitment, many things happen. As lawyers, you know, the number of times that we've had to counsel people in relation to this aspect of the law I think it's about 40% of our work. You have to cancel in relation to marriages and marriage breakdown. The problem with a marriage breakdown or relationship breakdown, it's also the interest of the parties. So one party feels that they've done better than the other, and then they have to take everything away. The other party also feels that, well, if I wasn't there, this couldn't have happened, and it's a partnership, and therefore, whatever is yours is mine. But sometimes whatever is mine is mine, and I'll explain why that phrase was used. Because in a settlement of financial dispute after dissolution of marriage, bear in mind that even in nullity proceedings, the woman or the man can make an application under Section 25 for support or for settlement of assets. The fact that the marriage was void or voidable doesn't mean that the person does not accrue rights. They do. So it doesn't matter what the case is. And the case that I was involved in, a particular case of Alfonso Brown versus Millwood, a case that I was involved in, I advised the court, went to the Court of Appeal, and the judge was very clear because the woman's case was that the man was already married to another woman, but they went to Ghana and had a customary marriage. Unfortunately, that didn't wash with the judge because they made so many mistakes with the first lawyer. And therefore, although I was able to get Professor Woodman to concede that if this was not there, would have been declared a marriage, the court felt that no, she's lied so much, they could not believe her. So it's the interest of the parties. Now, when we come to UK, the law is well defined. If you start from the case of White and White, and you know where the judges have highlighted 3 or 4 main areas. One is fairness and compensation for things lost and needs, and also bringing the party on equal par. If you go to Ghana, the Matrimonial Causes Act of 1971 clearly defines what should be shared, but also the Constitution, 1992 Constitution, was very kind and very favorable or generous to women, and said that on the breakdown of marriages, women should have equal share in matrimonial assets. So the English law developed so much. Initially was as to what you've contributed. But before the division of assets is done, the court will have to determine the assets which are what we call matrimonial assets. The English court will call it matrimonial acquest or non-matrimonial assets. When we go to Ghana, there's an aspect of matrimonial assets. And the cases that started from 1953 by Olenu in the popular case of Quarty and Quarty. At the time, he was saying that the children and the wife of the family are there to support the endeavor of the man, and therefore the woman should not expect anything. And then we move on to the case of Clark and Clark, and then Benchill versus Benchill, and the court developed. And then thankfully, in the early 2000s, we had a case of Mensah and Mensah, where the Supreme Court put its foot down and said that, well, we've got a 1992 Constitution, and Article 21 is what we're going to use. And then they talked about contribution and direct contribution into the asset. So before the woman could get something, she has to show direct contribution. And then we moved away to the latest case of Anyete versus Anyete, which is a Supreme Court case where the court said that in some cases it will be 50-50, but not in all cases. But the English position is always 3 things. Needs, equity and fairness, compensation for loss or damage caused because of the relationship. So in England, it's never been the case that you contributed. If it's a matrimonial asset or matrimonial acquest, it's always the case that is this marriage a need-based marriage? an equality or fairness-based marriage, a compensation marriage, or replacing damage or loss which is caused because of the relationship. They are very important, and I'm sure that eventually the Ghanaian courts will end up where the English courts are. The end results seem to be similar
Yeah.
to the English position, but the process to getting to the end
End
results
position.
are totally different.
Let's see if we can unpick the need-based fairness and equity and those ones. I'm always looking at a situation where before the marriage was contracted, Kwesi was doing well, Ajua was doing well. They have come together, they pulled resources together, and in between, they have made some wealth. Do I take mine away? Does she take hers away? And we look at what we acquired in between, or what? Where does equality and equity come in?
Well, when you look at the sharing of the marital fruits, it's fairness.
Okay.
When you look at need base, it's because one person needs something. And when you look at compensation because of loss as a result of the relationship, it is to compensate. So it's very easy for the judges. So they take the case. They know that these are marital assets.
Okay.
Very easy. Once they know these are marital assets, which of the three principles from the McFarland and McFarland case are we going to apply?
Okay.
Is it needs? Is it share of the marital fruits? Or is it compensation for loss or damage because of the relationship? When you go to the Ghanaian courts, it's not like that.
Okay.
The Ghanaian courts is always a case of has she contributed or what is fair? Now, their fairness is not the fairness we talk in England. It's a fairness and equity. So is it equitable fairness? It's not fairness as to 50-50, but it's fairness as to, okay, this person has done this. If you take the case of Anyate and Anyate, parties were in South Africa. Supreme Court said that, well, although all the assets were in the man's name, the woman was entitled to 50%. So she got a 50%. The assets were in South Africa. And the Supreme Court said, yeah, we've got jurisdiction over all Ghanaians anywhere they are.
In the world.
And it was a profound decision. I'm waiting for the court judgment in the case of Jan and Jan, which is Asamoah Jan and his wife, Mercy Jan. His wife, Mercy Jan, to determine the principle the judge used.
Okay.
But as you can find in all the cases in Ghana, starting with Korte, Clark and Clark, Mensa and Mensa, Anyate and Anyate, it's developed so much that now really they don't talk too much about, did you put in any money into this property? When they talk about, did you put in any money, then it's becoming more like what we call a trust case. Because under trust, even if you're not the legal owner of an asset, if you can show direct contribution, then you may become a beneficial owner of the thing, and the other person will be holding it in trust for you. But under English law, and that is why I'm not sure why the Mercy made her application in Ghana, because I understand she lives here with the children. That's what I've been told.
Well, information going around, as you've said, we haven't had the full judgment, but information going around that they have properties here in the UK, and that was awarded to the woman. Okay.
So, but the English courts are always applying one of the three principles: share of the marital fruits. So share of the marital fruits usually will come in cases where there is some form of contribution, either monetary contribution or some form of contribution. I'll give you a case I did in 1998. And I was a Ghanaian taxi driver. He had 6 houses. He was a taxi driver. He was working 18 hours a day. Now, if you take 24 hours in a day,
only 6 hours
he had
to rest.
only 6 hours. He gets home about 12 midnight. His wife is there, young woman, she's just come from Ghana. The girl was in her 20s, he was in his 40s. And he had bought 6 properties, 3 of them before she arrived, and 3 of them whilst they were still married. It was a short marriage, 5-year marriage, and then the marriage broke down. And he said, well, I'm sorry, but I bought my properties. You don't get anything. I then got a call from her. She came, we sat down, we looked at it. There were 2 children involved, and she explained to me exactly what she's done. It's basically make sure that he had a peaceful home to come. And that's why there's a difference between a house and a home.
Mhm.
So when somebody says that you are homely, it means that you've provided all the creature comforts for the person. And that's what she did. And that's what women do. I'm not saying all, I'm saying most women. And that is what they do. They provide a creature comfort for you to enable you further your profession, your career, and everything. And I see situations where even professional women have put their career and their advancement on hold for the man to go and earn more money.
Oh, my.
I mean, I've got a typical case where the woman can earn 4 times what she's earning now, but she refused to earn the 4 times because she wants her husband to go to work, or her husband wants to go to work. But I've always said that when it comes to relationships in our community, there's always the upper hand, which is the man who has the upper hand and does most of the things in the house, in the sense that he provides more money than the woman. Not all, but majority. So when the court comes to considering cases of this nature, has the man got a special skill? They have earning power, which he will always have had, not because of the woman, or has the woman contributed in certain ways, made sure that kids are looked after, there's a home, there's food ready, irons, anything from his shirts to his boxer shorts. And when you have a fancy woman, a very good woman, you get all those services provided. Now, when you've done so well, then it becomes a problem that what does the court do with the money that you've earned? And in those cases, the court will follow one of the principles. The other case also is a footballer's cases. But, in my life, even up until last year, I've always represented Black Star players and Premier League players. Always, I've always represented them, and even continue to represent some of them. The issue then becomes somebody who's a footballer and millions, like the Samoa case. In that case, someone will say, well, what did the woman do exactly?
Yeah.
Because they've had a high life, private jets mostly, luxurious life, bought Porsche for her, Phantom. I hope you know one. Phantom is almost about 350,000, and looked after her, had the best holidays, private holidays.
You've had 3 children.
3 children. She hasn't worked before, and sometimes they delve into doing things for other stars' wives, and it's almost not successful. They just go and waste money. So when the marriage breaks down, it feels like, well, I'm the one who's going to play football. Yes,
I've earned all the money. You have
Yeah,
enjoyed it.
I know. I mean,
So
my
why are you
parents-
asking me to give you everything?
I'm going to grow till about 80 something or possibly 90. I can't work the way I've worked, and I'll not be earning money, in the next 4, 5, 6 years. And the courts have always listened that, yes, that's true. So what you've earned, we're not going to apply the equality
Okay.
or share the fruits of
Of
the
the marriage.
relationship, but then we look at needs.
Okay.
So the needs of the wife and the children will be the needs that they are used to. So if they were private schools, then they will have to go to private schools. And if the wife had a car every 3 years, which is what we've always negotiated if I'm on the woman's side, and for the footballers that I also represent, if I'm on the footballer's side, then again we try to beat it down. But it's all about negotiation because you want to prevent the court from making a pronouncement. And the footballers may not like to have their cases heard here. I remember one case that I was involved in. It was a solicitor who was representing one of the Black Star footballers in the Premiership, This is about 2008, 2009, and big football star. He used to play for Chelsea. So I was involved because there were aspects of the case that they've read reports that I've written, and so I had to use my skill. Were able to use a skill, and the woman who was receiving £40,000, they didn't have any child, £40,000 a month as support and legal fees from the footballer, because of the work that I did, she was getting 5,000, and eventually the case was struck out, because we were able to prove they were never married, even under Ghanaian customary marriage. So it's always important how these things are dealt with. But as I've said, a marriage is a partnership. And if God blesses you with assets, because not everybody will be successful. And I say success comes from God, because it's God's direction to work. Because you may have somebody who's got the same energy as you and can run as faster as you, but they cannot be successful, even as footballers or athletes. It's God who gives all these gifts. And if God is giving you the gift, I've always said that where it requires sharing, then it has to be shared.
Where it requires sharing has to be shared, and the equality bit comes in, equity bit comes in, the need of the parties, and definitely talking about what was acquired when the relationship was on. We're live on BWTV, and the program is The Community. And this afternoon, we're looking at what is yours is ours, and what is mine is mine. We'll be coming to that phrase. And Kuben mentioned that there's a reason why those ones were couched there. Financial settlement after a divorce situation. What problems there are, how to avoid them. If you have any question, you can text us on 07399208468. I said text 07399208468. Send a WhatsApp message or a voice note to 07950422780. Now, today we have introduced one studio number 0208 493 7345. 0208 493 7345. That's where you can call, and we can take your call and speak to you on the phone. But if you want to text 07399208468, WhatsApp and voice notes 07950422780. So you have a variety to choose from. Now we're going back to the discussion, and I'm going to ask this particular question. If, for instance, A being the woman, before they got into the relationship, had assets back in Ghana or outside of the UK, those assets were enhanced because of the relationship. Now, there's a divorce and demands are being made. Can the lady in this situation A ask that that was given to her because that was what she brought into the relationship? And can she justifiably also claim that any enhancement and other developments of the one she brought into the relationship be given to her as well? And somebody started calling her. But whoever is on there, please just hold on. Let me get my answer to this now. Come and take your call.
Well, so usually when you bring an asset into the relationship and it's used as a marital asset or as matrimonial home, it becomes matrimonial asset under English law. Some people may have inherited property. I'm dealing with a case now, and I don't know why some of our people, when there are Ghanaian laws involved, they go and take English lawyers. It's just hopeless. They've just messed up his case and managed to punch holes in the case, so much so that something that he claims that he inherited from his father, it's clearly not so. So if you bring an asset into the relationship and it's used as a marital asset or matrimonial asset, then the English courts will always say that it is a marital asset. Under Ghanaian law, with the cases that we've had so far, and you would struggle to say that is a marital asset because the person can say that this is an inherited property or is a property that I brought into the marriage, they will always be able to distinguish that from the marital asset. But under English law, if it's a long marriage, the asset had been used as a marital asset, and it's a needs-based relationship.
Okay.
So when there's a needs-based, it means there's not enough money to go around. So every asset counts, including pensions and all the insurances, inherited assets, and all those things. For example, you've got two parties, a man and a wife, two children. They started with a council flat and managed to buy the council flat. Now the equity in the council flat is about 70,000. And they've also got one house in Ghana, which is worth about 70,000 pounds. So in that case, really, whatever the man may have brought into the marriage, even if he's the one who paid all the deposit for the council accommodation right to buy, still, because as a small money claims, then it's going to be very difficult to say, well, I paid all this deposit, so I have to have all this deposit before we share whatever we have to share, especially if there are young children involved. Yeah.
Would it be right for the both parties, before they sign the marriage certificate, say that in the event that it is a break, these assets may not or will not be counted as part of the things that we look to distribute and share?
Okay, so the point you raised is what we call a prenup or a prenuptial agreement. Usually, when a man meets a woman and they are both in love, they are prepared to say or do anything so that they can sign a contract, or the contract, I mean, marriage. So, under English law, prenups are not enforceable in most cases. In
Right.
some cases, they are enforceable. They are enforceable usually in big money cases. Just remember the three principles I gave you. Sharing of the marital fruits, needs-based, compensation for loss or damage or disadvantage because of the relationship. Now, if you've got a prenup and the equity in the house is 200,000, the man has to leave the house, the woman has to live in the house with the children. I mean, nobody is going to say that because you said you will always keep the house, then the house will be given to you. That won't happen.
Well,
But in big cases, there's a case of Marcher versus Marcher, a young German man and his German wife. They signed a prenup, and the court said in that case the prenup was valid. But in certain cases, the courts have said the prenup is unenforceable because you cannot tie the hands of the court when they are applying their Section 25 of the Matrimonial Causes Act. In the same way, prenup is not known in Ghana, but you can always have an agreement and just make sure that you protect your assets. I've always said that when you love someone, you're very careful with what you give them and make sure that your kids are also provided for, because children are innocent parties in all this and they should not be punished because of either your hurt or your emotional difficulties with the breakup.
what is yours could be very, very objective and fine. What is mine could be fine. But what is yours is ours. We'll be coming to that to understand why the phrase, whether it does operate in the UK and in Ghana as well. 0208-493-7345. Send a text 073-992-08468. WhatsApp only. Voice notes in addition 07950422780. I think at this point it is very right to say thank you to BWF Solicitors. And I want to remind you again that on Saturday, the 11th of November 2023, we'll be having the Ghana Property and Lifestyle Expo at the Pestana Hotel, Battersea, opposite the Battersea Park. And Uncle Ben, the senior partner of BWF Solicitors, is one of the resource persons to give us insight into what needs to be done legally when you are going for a property in Ghana, either it's by land or whether it's a property already built or whatever it is that you have to do. We'll be right back. The person on the line, please hold on, don't go away. We'll take in this very quick message, and when we come back, we'll pick up your call.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Ready for the ultimate property and lifestyle experience? Get ready for the Ghana Property and Lifestyle Expo 2023, coming to 2 exciting locations. Join us in London on the 11th and 12th of November, where leading reputable real estate developers will be waiting to meet you face to face. Be inspired by industry experts as they provide thought-provoking panel discussions and live Q&A sessions. And finally, mark your calendars for the 16th and 17th of December when the Expo lands in Accra, Ghana. Experience the vibrant lifestyle and rich culture of Ghana while exploring investment opportunities in the thriving real estate market. Our expo will also feature exhibitors ranging from banking and legal services to estate and property management. Get all the support and information you need under one roof. So whether you're looking to invest, visit or simply explore the world of real estate, the Ghana Property and Lifestyle Expo 2023 is the place to be. Don't miss out on this incredible opportunity. Book your tickets now via Eventbrite for the Ghana Property and Lifestyle Expo 2023. Dream it, live it. You don't want to miss out.
About 400 people. Yes, we're back, and thank you very much for sticking and staying. We're live on the Community and the Law. And as I mentioned, we have somebody already on the line who is waiting. Thank you for waiting. Hello, good evening.
Oh, hello, good evening. This is KK. I have a quick question to Amifo Uncle. Uncle, my question is, if there's a divorce and quickly one party forms a relationship with someone else, let's say a rich partner, and they live together.
Mm-hmm.
Now, can the other party, who is the weaker party financially, make a claim against the ex-partner, take into consideration the assets of the new partner, the rich partner?
It's a bit of a complex scenario.
And if there is no, especially when there is no financial order in place after the divorce.
I mentioned earlier that it's a bit of a very complex scenario you are giving us. If you don't mind, take your time. Let's unpick them one after the other. Now, there is one. There's an initial relationship that's broken down, right?
Correct.
Good. And then one party of the previous relationship is going into another relationship with a rich person.
Correct.
Good. And the other part, the other person of the previous relationship is basing the demands on the new relationship that the person is gone to because it's with a rich person, can that person make any demands on that relationship? Is that what you're asking?
Yeah, taking into consideration, asking the court to take into consideration the new rich partner's assets. So whatever form they have to complete when he's or he or she is being asked to declare his or her assets, that means that he or she has to also include the rich partner's assets.
That's it. Does that happen, Uncle Ben?
Oh, yes. So when,
Can you hear Uncle Ben?
I think no. I think I have to go back onto my phone. Sorry.
No.
can you hear me now?
He just started speaking. Can you hear him now?
Can you hear me?
Yes, I can hear you.
Okay, so yes, your new partner's assets can always be taken into consideration, even when you divorce and you've remarried. If somebody divorces and remarry, properties cannot be distributed anymore, so that's gone. But when it comes to paying of maintenance payment and some other distribution of assets, your new partner's income will always be taken into consideration.
I hear you.
Come again?
Oh, yeah. Thank you.
You're
I
welcome.
said NJ.
Is the foot on the other? Is the shoe on the other foot?
Thank you very much, Uncle Ben.
You're welcome. Anyway, you can also call in 0208 493 7345. Just something in jest. It looks like he probably is a rich partner.
Yes.
The way he said Ajay.
Yeah, that is why when you look at a properly drafted consent order, they tie in certain loose ends. What I always tell people is when you're going into a new relationship, you always have to finish the old one completely before you go into the new one. Because somebody can always come back and say, because when they take your household income, because your household income includes the income of your new partner, that will always be part. It doesn't mean that she will be compelled to pay money, but it means that your household income, if it was initially needs-based, now you've got more money than before. So what was a needs-based is now become maybe a compensation or a fairness or equitable distribution base. Yes.
Right. 0208 493 7345. Send a text 0739920848. WhatsApp and audios 0795042278. Uncle Ben, before we went on that break, I was asking, why do we say what is yours is
Okay, so when you say what is yours is ours, we always use a situation of a man and a woman where the man is working. So the man is going to buy a property and he's put his sole name on it. Now, so that's legally that's his. But in law, the woman will have a beneficial interest in it, either through trust or because of the marriage. So what is yours is ours. But in certain cases, what is mine also stays,
right.
especially if it's not a matrimonial asset and it's an inherited asset. So that what is yours is yours. And that is why the phrase, what is yours is ours and what is mine is mine. I'm not saying that I will share in yours, but I won't allow you to share in mine. All that I'm saying is that there will be situations where what is for one person belongs to both of them. And there will be situations what is for one person will be for that one person.
Doesn't normally happen. Hold on to that. Let me pick up the score. 0208 493 7345. Hello.
Hello, good evening.
Good evening.
Good evening, Kwaku. Good evening, Uncle Ben.
Good evening.
Hope all is well. It's been a long time, Kwaku.
Is that my Antobam?
Yes, it's Uncle.
Uncle Ken, how are you?
I'm fine, sir.
Good. Now let's hear you.
Kwaku, I have two questions. The first one is about Zambrano application. When you are filling a Zambrano application, Uncle Ben, there is a section of criminality. I've been listening to you, and you always say with immigration, you always have to declare. But Section 11 of the Zamrano application, normally it's written that, please note, you are not required to declare non-recordable or spent convictions. But here's the case: it's an immigration application. So in that wise, are you to omit not to declare if it's spent or not? That is number one. Number two is about this no recourse to public funds for these
students,
students,
student learning dependents. Yeah.
That's right. Is this something that is good for us or is bad, Uncle? I want you to give me a bit of explanation. Right
Well,
now,
you want his opinion, not an explanation, is there?
okay, an opinion. Because before you qualify, normally is to do with people with children, and you have children and your responsibility, and then things that you do is a bit difficult for you. I think that qualifies you more. But here's the case: from January, as you said, nobody should bring any dependent if you come to be a master. And at the same time, they said now you can go for recourse. So how many people are going to qualify then? This is just something I wanted to know. Thank you very much.
Oh, okay. Would you want to stay and listen?
Yes, I'm going to put it down there.
Okay. All right. Oh,
Okay. So the first question was under immigration laws, no criminal conviction is spent. So we have the Rehabilitation of Offenders Act, ROA 1986. I think so. I think it's 1986. And that's there to protect people so that when a conviction is spent, you don't declare it. But for immigration purposes, no conviction is spent. So once you've been convicted before, you have to declare. It's for the Home Office to decide whether they will use a particular conviction against you or not. So the ROA does not apply under immigration rules. They've excluded it. In relation to the case of PA, I have to remember her name to remember so that I don't use her name. That's why it took me a while. PA and her child NA, who came here as student dependents. Yeah, we know from January you can't bring dependents, but there are dependents who are here. And just remember that the UK takes a very proud interest in children under Section 55. And when the court was looking at a case of PA and NA versus the Secretary of State for the Home Department, which is that all immigration migrants in this country, if they meet the requirements, can always apply for the no recourse to public funds to be removed. It doesn't mean the person is going to claim benefits. But yes, if they are claiming benefits, just remember that if the condition of their visa says that they should be self-sufficient, that is something that could affect them. I'm not saying well, but it could. And for a short period, if somebody is going through an upheaval and they claim benefits, I'm sure they will get away with it. But if it's for a prolonged period of time and clearly shows that you cannot maintain and accommodate yourself without recourse, then one of the mandatory requirements of the immigration rules would not have been met.
Okay. 0208-493-7345. Hello?
Hello.
Good afternoon.
Good afternoon, sir.
How are you?
Oh, by the grace of God, all is well. Not all that well, but I'm managing. It's okay.
No, you'll be fine. Don't give up. Well, let's hear you. Uncle Ben is here to answer your question.
All right. Thank you, Uncle Ben, and thank you to you. And
you're welcome.
I must also thank all our people watching. It's best to be watching BWF solicitors.
Thank you very much.
Creative programs, and God bless you for that. You know, Uncle Ben needs to be a reverend minister for us because he's superb in terms of law. But from going to my question now,
yes,
the stubbornness. That is why I said I'm not all that fine. The stubbornness and the devilish act of my wife have led me, without any option, to report to the relationship. Let me check from here. Relationship breakdown at Home Office. That I'm no more with her. You know, I just saw that, and there was a form I filled and sent. I want to know: do I still need to get divorce certificate because unfortunately I didn't consult BWF
So
before
are
I
you
did
are you,
that.
are you saying that you have reported a relationship breakdown to the Home Office?
Yeah, I have
Okay.
done that.
Now,
But I did.
hold on. I'm trying to unpick it so we can have a very quick and easy answer. Were you legally married to the person?
Yes, with marriage certificate and all that.
Okay. So then, having reported the relationship breakdown, do you want to get the marriage dissolved legally?
Oh, so is there because I don't know much about it. I thought with that I have sent, that is all.
No,
Or
the
it's not
Home
like,
Office is not a court. The court dissolves the marriage and will give you a certificate, the absolute one. So then the
oh, okay.
court will have to dissolve it, not the Home Office. Yes, you are reporting your relationship breakdown. Home Office will take record of that, but legally the marriage is not dissolved.
Wow.
Agben, am I right?
Yes, the marriage is not dissolved. Home Office cannot dissolve your marriage even if they wish to. That has to be done by the court. So if you've reported it to the Home Office, that's one part. The other part is for you to take, is to break the marriage and basically to file for divorce so that the marriage can be dissolved. Yeah.
Wow. So what I have done is just some part.
Just one, just the first step. That's it.
Oh, okay. So what may be the consequences if I don't do anything further? Like what lawyer is saying.
You're still legally married to your wife.
Huh?
Yes.
But I don't want her. I don't want her because she's something else, unfortunately.
Well, then you have to do the rightful.
Oh, okay.
Yeah.
Okay.
Okay. Sorry about that, but do the rightful. Yeah.
All right. Okay. Thank you.
Okay. All right. 0208-493-7345. Hello. Hello.
Hello, good evening.
Good evening.
Thank you very much, Uncle Koko and Uncle Ben.
Thank you too for staying with us.
Yes, so I just want to ask this question. A friend of mine did ask me to ask for this question.
No worries. Go ahead.
So he said he's on family roots, so he was doing 10 years, but the 10 years will come to an end this November or December, and then he's done the English test, the life link, he's done the B1, but at the moment cannot work. So already it's 2.5. They took the no request from it, but he's gone to consult his doctor for a letter. So that is what he'll be using to support his indefinite stay. Is it likely that he'll be given or he will not be given?
What was the purpose of the letter? Was it to apply for a fee waiver or something?
No, the fee waiver has already been taken, but because it's not working, he needs to, and it's on the universal credit, PIP, and so forth. He needs to consult the doctor for his disabled letter.
Okay. Agwen.
Yes, well, she said she's done the English B1 and the life in UK, and she's applying for indefinite leave. So I'm not sure what the letter is supposed to do. But if it's to help with the application, of course, anything that explains your circumstance is welcome. Unless, of course, there's something else that you haven't told us. So, what is the concern here? Tell me, what is the person worried about?
She wants to know whether it's likely to get the indefinite stay that.
Why is she worried that she might not get it?
I don't know. I was a bit concerned about the when they said that someone must reach a certain amount for the payment, 80,500, 80,000.
Oh, but you said she was on a 10-year route.
Yes,
Yeah, the 10-year route, there's no requirement for maintenance and accommodation. That's why it comes under the 10-year route, purely either EX1 or outside the rules, purely on Article 8. So maintenance and accommodation is not part of it, okay?
Okay.
So don't
Okay,
worry,
thank
don't
you
worry
very
about
much.
it. Yeah.
Okay. All right. Thank you for your call. Yes, we still have time to take a few more calls. 0208-493-7345, 073-992-0846. That's for text messages, and for WhatsApp and audio notes, 07950-422-780. And before we started picking the calls, I was asking that what is yours is ours, what is mine is mine. Does it often happen?
Well, in real life, we don't have multimillionaires everywhere. So you don't have situations where you've got so much money, you keep what is yours, and you only share what was acquired during the marriage. What will usually happen is that most people will be what we call the needs-based cases or small cases. Maybe the money that they are fighting over is under $1 million. In that case, the small children, maybe 10, 8, and 6. The 6 years will have at least another 12 years, potentially another 14 years to go to university. And therefore, every penny that a woman needs to support the child will be provided for. So even if there's asset which was brought in or an inherited asset, because it plays a role in the matrix of the division of assets and it supports all the parties, the court is not going to say what is yours is ours and what is yours, what is mine is mine. In that case, it will be what is yours is ours and what is mine is ours. And that they put everything into the marital pot so that they can do the proper distribution.
Okay. Well, if you have a text, you can put that in the comment section below on your Facebook page or YouTube page as well. We have one here that was sent in as a WhatsApp message. Let's pick that one up quickly and see if Uncle Ben will help us do that. Please, so I have applied for a visa for my child to join me in the UK. She will be going for biometrics, but on the documents checklist as child applicant, she's supposed to sign at the appointment. After that, a responsible adult is supposed to sign at appointment. I mean, the UK, the child is in Ghana. How should I go about it? Can I sign everything here in the UK and upload so that the child will not sign anything? It's my friend who will take her to the TLS contact center. So can he also sign? If someone signs, will that affect sole responsibility for my child in the application? Is it ideal for a sick grandparent to go and thumbprint for me and the child?
Well, the advantage of these applications is that it's done online and the signature can be done either electronically or you print, which is waste of paper, print, sign, scan. So if you've got an iPhone, if you get a form, I wish I could show a form, but I can't.
I think maybe I can quickly put a form on here.
Yeah. And then you show them how to sign. And yes, you can sign for her.
I hope it will work.
Yes.
Prof, let's see if we can share this one. I'm trying to be techie here. Because I have a form. Yeah, I have a form in the message that the person actually brought us. Have you received anything on there? Okay. So let's see if we can put that on there. The form that this person is talking about is being shared here. And let's see. Did it come up? Oh, okay. So on the form, it says name or description of document. Please tick the following boxes to confirm you understand the application process. The documents ticked in this checklist are all the documents I wish to use for my application. To the best of my knowledge and belief, the documents I have used to support my application are genuine. I understand the The commercial partner is not in charge. Oh, wow. Important. Do not sign until you are at your appointment. Date. Applicant's name, applicant's signature. Date. Responsible adult's name, responsible adult signature. Could it be either of them, one or the other?
Yes,
Or it has to be
the
both?
parent here should always sign it. The Home Office has a knack of causing mischief, and they will intentionally ask you to bring permission from a guardian or a parent that you're traveling. The parent here who is a sponsor have always assumed that the guardian the child is living with or the other parent is a person who has to give the consent. Please don't. If they ask you to give consent, you give the consent. So you are the one who is in the UK. Your child is coming to the UK. So you write, dear sir or madam, date of birth 13th of April and 2013. So that means she's 10 years. I am Mansa Menu of Abenkwa Road, East London. Right, to confirm that I give consent to my daughter named above to travel to the UK. Please accept this as my authority or consent for her to travel. Simple as short. Add it to the application. You're a parent, your name is on the birth certificate. They cannot reject it and come back and say, well, no, we want the other parent. Because when you get the consent from the other parent or the guardian, they always use that against you when there's issue of responsibility. They will say that, well, if you say you're the one who takes all the major decisions in the child's life, the child relocating to UK is a major decision, but you didn't take that decision. Somebody had to give you consent to bring your child. So it means the person is taking the decision. Never do it. Don't ever fall for that. It's a very silly thing that they're doing. They always use it against people. Please, if they're playing a game, also play the game with them. You sign it on the child's behalf. You write the consent on the child's behalf, not any person who is not involved in the child's life.
Okay. 0208493735. Somebody is calling the mobile. I asked you not to do that. Please don't. Please don't. Call the number I am giving you now. It's 0208493735. Okay. Please, Oreku, can someone with the diagnosis of dyslexia be exempt from the Life in the UK test, Uncle?
Somebody with a diagnosis of what?
Dyslexia.
Oh, yes. Why not? I mean, if that affects you writing the exam, because all the exams involve some form of reading. So it's reading, listening, and speaking. With the Life in UK, there's a bit of computer work. If that affects it, then yes, you can get a doctor's report and add it to the application. Yes.
Okay. But would a certain age be criteria for exemption?
65.
65.
Yes.
Okay. Right. 0208493735. Text 0739920848. WhatsApp only 0795042278. So just for those who follow us all throughout the week on the various other programs we do, this will be our studio number. So remember, keep it very closely to yourself so you can text in. And when somebody says that wants to change from one skilled worker route to one, what does the person have to do?
So if you want to change from one skilled route to the other, you can always do that. We always encourage people to move up. You find a new sponsor, they will sponsor you, they will give you a certificate of sponsorship. You then use that to switch, and then once you've switched, you're fine to go.
Okay. 0208493735. Hello? Okay, sorry. I've got a person back. Hello? Hello?
Hello.
Good evening.
Evening.
Hello?
Yeah, I'm in front of my screen. I'm watching Okobe talking about immigration stuff.
Yes.
Okay. I've got a few questions to ask. I don't know.
Yeah, go ahead. We're ready for you.
All right. Okay, thank you.
Do me one quick favor. Can you go down the volume of your TV set? then speak to us through the telephone.
Yeah.
Yes.
I've got a sister in Africa, Nigeria.
Mhm.
So I've been thinking of ways to bring her into England. So I don't know. And yes, I definitely know maybe first quarter of next year I need to book an appointment with BWF just to figure out plans and way to bring her in. But I was very happy now when I saw Kuben and I was like, yes, it's the right time to put this question straight. So I don't know which of the possible ways I could bring her in.
What is his nationality?
What's your nationality here in the UK?
I've got pre-settlement here in England.
Pre-settlement.
Actually, Okuben do that application successfully for me. So,
Okay, so you got pre-settlement.
yes.
Akuben.
Well, so if you've got pre-settled status, that means that you're a family member of an EU national. Your junior sister will be your extended family member. Unfortunately, the time to bring her is gone. It was 31st of December 2020. Unless, of course, you want to pay for university fees or college fees or some school education to come.
Oh, okay. Well, I think it's gone, but we've got another person. Hello?
Yeah, I'm listening.
Oh, okay. Okay. Your line went off, so I thought you had dropped it. Sorry about that. Did you hear what Anchorman said? Hello?
So you say that again?
Yeah, Anchorman said you having pre-settled status means that you're a member of an EU member and your sister is an extended member of your family. Before 31st December 2020, your sister could have qualified, but under the new dispensation, no. You may want to enroll her in a university or something or use another route, but you can't use the pre-settled status for your sister directly like that.
Okay.
Yeah. But book an appointment, come and see Uncle, and there will be.
Like I said, I'll do that first quarter of next year.
That would be
maybe
brilliant.
February. Yeah,
That-
I'm doing that straight away.
That would be brilliant. Thank you for your
Okay.
time. And keep watching. We're back same time next week with another edition, so you can have us again. All right. Thank you. 0208493745. We'll have time to pick up one last call, then we'll be getting to our quiz, which will be based on our nuggets. So before then, let me quickly remind you what we talked about in our nugget segment. It's about reasonable adjustments. Employers are required to make reasonable adjustments for job applicants and employees with a qualifying disability when the provision, criterion, or practice places them at a substantial disadvantage relative to a person without a disability. Employers are not required to make reasonable adjustments unless they know or should reasonably know that the employee is disabled and will be placed at a substantial disadvantage due to their disability. So think about that. I'll be giving you the scenario. But now, let me say thank you to BWF Solicitors. Well, listen, if you want the best, if you want a trustworthy organization, if you want a legal firm that understands your situation, want to handle that successfully well for you, you're going to BWF Solicitors. 4th floor of the other house, 214 to 218, Tottenham High Road, Seven Sisters, London N15 4NP. 0208 493 7340 is their telephone number. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And they bring us the community and the law live on BWTV.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate, or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues. international trust advice, including residence, domicile issues, wealth preservation, a fast, efficient service from SRA regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Yes, thank you for staying. And we're going to go to our quiz segment, as I mentioned prior to the break. But there's one quick comment we want to pick up from our comment section. Derek says, hello, Riku and Uncle Ben. Thank you for your support for the community. I'd like to ask, if I switch as a student to the skilled worker route, does my switching automatically cover my dependent partner? Or he or she has to make an application as well? Agreed.
Yes, she has to make an application. It's not automatic.
Oh, okay. Well, it's a straightforward answer, so my friend, let's do that. Okay, now, having given you a nugget talking about reasonable adjustment, let's see okay, let me take you through that again quickly. Employers are required to make reasonable adjustment for job applicants and employees with a qualifying disability when a provision, criterion, or practice places them at a substantial disadvantage relative to a person without a disability. Employers are not required to make reasonable adjustments unless they know or should reasonably know that the employee is disabled and will be placed at a substantial disadvantage due to their disability. ACOM Limited versus Malon 2023 EAT case based on Equality Act of 2010. Now, the question. Equia Mansa works for a care home as a carer. As part of her duties, Equia helps lift clients so they can get around. Equia informs employers about her lower back problem as she's been diagnosed with sciatica. She's asked for reduced hours and office-based work. Equia's employers explain to her that they do not have need for an extra office hand, or they do not need an extra office hand. That's what lawyer for both do maybe. Equia is contemplating suing her employers for discrimination and constructive dismissal. Doing her work or carrying her duties, she lifts patients and clients so they can move around, helping them here and there. In doing that, she's also developed a problem. And doctors have said that she's got sciatica. That's very painful. She asked for reduced hours, and instead of being around the ward all the time, she could do office-based work. Employers said, no, we do not have the need for an extra office-based staff, so you can't. Then the Equia said, okay, well, I'm going to sue you for discrimination and constructive dismissal because you are telling me you can't give me a job because I'm having a problem. What are the likely outcomes? One, Equia will win because the employer must make adjustments for Equia to work in the office. As a business does not need extra hands, they can only assess Equia's need and give her feedback with reasons. That's number two. Number three, Equia is not qualified to work in the office, so her claim will fail. What are the likely outcomes when Equia sues the employers for discrimination and constructive dismissal? Equia will win because the employer must make adjustments for Equia to work in the office. Now, number two is also saying, well, as a business does not need an extra hand, they can only assess Equia's needs and give her feedback with reasons. Well, unfortunately, you're suffering from sciatica. We can't have you in the office because there's no post for you to occupy. So unfortunately, we may have to get rid of you. And number three, Equia is not qualified to work in the office, so her claim will fail. Now, drop your answers. Let's go. Is it 1, 2, or 3? We have Christiana Sewa Puku watching. Ademununkum, thank you for watching. Diana Sapon, Aineba Kofi, Adam Asabri also watching with us. Nana Yawa J, I'm acknowledging all of you. Thank you for your time. Emma Inkansa, Evangelist Ishmael Okule, Daniel Opeku. We have Nanetia Hine watching. Tilly Duma is here. Nanajiman, class prefect, is here. Dr. Sadom is around. Margaret J, you're around. Well, somebody gives me an answer. Demunukum says it's number one. Number one says what? Akuya, can you push it up for me, please? Okay, Akuya will win because the employer must make adjustments for Akuya to work in the office. Well, that's what they say. Christina Sepuku, thank you to lawyer. Thank you, Christy. But I need your answer. So come on, let's go. Let's get going. Let's get it going. Let's get it going. Is it one? Akuya will win because the employer must make adjustments for Akuya to work in the office. Two, as a business does not need any extra hand, they can only assess Akuya's situation and provide her with feedback with reasons. And Akuya is not qualified to work in the office. Is it one, two, or three? I'll just give it a couple of minutes and we go to see what the answer would be from the what do I call it? From the realms of the Lord, maybe. Prophet 0208493735. Derek says it's number two. As the business does not need extra hands, they can only assess the Akuya's needs and give her feedback with reasons. Okay, well, that's your opinion. Let's see what it says. Okay, Uncle Ben.
Okay, so if we go back to the nuggets, which was shared on Monday, it says that employers are required to make reasonable adjustments for job applicants and employees. So job applicants and employees. Akuya is an employee, so she falls within. With a qualifying disability, Akuya has sciatica. Is it a qualifying disability? Yes, it is. Because it limits her mobility. So, she may qualify for disability. When provision, criterion, or practice, PCP, places them at a substantial disadvantage relative to the person without disability. Without her sciatica, she was working. With that, she obviously has reduced mobility. It's a very painful occurrence at your lower back or any part of your body. But the employers are not required to make reasonable adjustment unless they know. Do they know? Yes, she's told them.
She's told them, yeah.
Two, or should reasonable know that the employee is disabled, but in this case, they know, and will be placed at a substantial disadvantage due. And she's told them that it's placing her at a disadvantage. What did she ask for? She asked for two things, not one.
Let's go to the
So she asks for, at paragraph 2, she has been diagnosed with sciatica. She asks for reduced hours
and also to work in the
office base. So the duty is there under Section 20 of the Equality Act. You need to do an assessment. You do an assessment, professional assessment, not a friendly chat assessment, professional. You fill proper forms, you find out the issue. You may even send it to your own doctor, or you ask a GP to comment or give a report. You then look at your needs and you say, okay, Akuya, so at the moment you're struggling, you want reduced hours. Can she do the reduced hours? It's part of the assessment. Can she do it? If she can do it, then the employer must give her the reduced hours. With the office, that will be a specialist skill. Somebody who's working in a ward or in a nursing home purely as a care assistant or care worker. Is she able to do the office work? If she is able to do the office work, will her sciatica be a problem as well? And that forms part of the assessment.
Right.
Do you have maybe the office is a small office. All it does is go one desk, one computer, one chair, one person, one man, one machete. You've read that Nigerian novel.
And if you go to Ghana and say one man, one seat.
One man, one seat. So it's one office, one person, they cannot really put you in the office. Also bear in mind that the person who is working in the office, a typical healthcare person will be earning about £10.75 up to £12. Maybe he's earning about £20 an hour. They can't afford to pay you. So again, that's not something that they can afford. So the answer will be 2. And there will be a reason. So Adai, let's bring the reasons, the full reasons. Yeah. And the answer this week is number 2. An employer's failure to make a reasonable adjustment for a worker or applicant suffering from a disability will constitute discrimination under the 2010 Act. However, if there are no reasonable adjustment that can be made, you must explain your reason for this. And that's what they did.
They did. Okay.
And that's it.
Well, just before we got Uncle Ben to do the answer, Tina Saki said number 2. So we will accept that because you brought it in before the answer was given. Rebecca Mwaku, you also said number 2. Derek Yeboah, you said number 2. So those who did number 2 are correct. Well, I have said, and I want to say again, that very likely in December, we're going to have our quiz. And people are going to win, like our brother who is enjoying so much in Ghana. Maybe I'll change from the seats to another, and I can also participate in that because I want to win. But in any case, BWF solicitors will be wishing you a Merry Christmas and, of course, a prosperous New Year. We'll be going to that. So keep patronizing their services. Visit their office, 214-218 Tottenham High Road, 4th floor of Vienna House, and send them all your legal queries and applications and the rest of it, and they will help you. They are our trusted partners. BWF solicitors want to say thank you. But before we go, I'm not a person to break tradition, so I'm going to hand over to Uncle Ben and for a moment or two for him to give us a summary of what we have discussed this afternoon. Uncle Ben.
So what we've discussed today is that unfortunately when marriages break down, there some cases there will be need for what we call financial settlement, is to make sure that each party goes away with some modicum of respect and also the means to provide for themselves and any children involved. And in the UK, there are 3 main guiding principles that the courts will follow. That is whether you share in the marital fruits, and that is talking about equality, or whether or not it's a needs-based because it's a low income or small money and there are children, or that because you've suffered a disadvantage because of the relationship, you must be compensated. In Ghana, both under Article 20, 21, 22, that talks about this part of our law, the courts have moved on from 1953 to 2023. They are in the modern world. And the court is doing marvelously well for both women and men. And clearly the court's emphasis is on the Constitution, which empowers the court to make sure that when it comes to division of assets, that equality or equity comes into play. And it may, through that, mean that it will be 50-50. But in very rare cases, will there be a situation where somebody's made a contribution and they don't earn anything from that. So just be mindful that the courts will factor in so many things, and therefore we need to be careful. Thank you very much.
And with that, I want to say thank you to all of you for your time, your contribution, your calls, and your texts. So very much appreciated. What is yours is ours. What is mine is mine. We have unpicked that and seen how we can overcome those situations. We looked at the whole thing from the UK and Ghana perspective. Thank you to Uncle Ben. Thank you to BWF solicitors. Thank you to all our technical staff and admin staff. To Sandra for winning the Employee of the month of October, and to Sheila and Padmo for the aesthetics and the admin. Sheila's doing so very well. One day we'll have to bring her from behind the scene to the front. Anytime I say that, she says, no, that's your job. Anyway, she pushes me to do my job. Thank you very much, Sheila. All the best. And to my studio producer, Professor Ade, for your tenacity and hard work. My name is Umeku Frimpong. It's been another edition of The Community and the Law. Good evening.